The views, thoughts, and opinions expressed in the podcast belong solely to the hosts and not the host's past, present, or future employers. Hello, everybody. Welcome back. Thank you for joining us this week on Breaking Down Security. It's just me, all by myself. Mr. Brian, Mr. Betcher, Mr. Lynn are not here this week or next week, potentially, because I recorded this on a Saturday morning with our guest. This was a time-sensitive product, and wanted to make sure that this got out because it was still, we talked a little bit about some of what we're going to talk about this week on our news stories the previous week, and I wanted to make sure that we had somebody in the know who could speak more intelligently about it than myself. So I'd like to just go ahead and get right into our discussion. I'm going to start our timer right now to make sure that we're cognizant of the time. I'd like to welcome Fred Jennings to the show. And before we get started, I would like Fred to go ahead and put out his disclaimer. That way, everybody is fully and well aware of what we might talk about today.
Sure, and thank you for the intro. So I'm
Sure, no
Fred
problem.
Jennings. I am a cybersecurity lawyer, and I shall give my necessary but horribly boring intro of I am a lawyer. I am not your lawyer unless you are paying me for those services. Nothing that I'm saying is meant on behalf of or for the purposes of any of my clients. And this is not legal advice and should not be taken as such. And with that, we're good to go.
Excellent. Okay. So the reason we had Fred on this show was kind of inspired by a discussion between Katie Masuris on Twitter and a gentleman, I believe, by handle of _MG_, who works for a company called Randory or Randory. I don't know what it was last week, and I still don't know this week. But so there was a discussion about a company like Randory using O-Day in security pen tests or security discussions, and there was a larger discussion about disclosure and vulnerability equity programs, with which I was sadly ignorant of what a VEP was. So I had to go do some discussion and discovery of what that was. And so Fred, just for everybody to understand your bona fides, maybe you could tell people a little bit of your background in law and how vulnerability disclosure and equity programs, what's been your involvement in those?
Yeah, sure. So I got my start in this area, among other things, doing a lot of cybercrime defense cases, often involving security researchers who, for one reason or another had triggered the defensive mechanisms of the law against, vulnerabilities they disclosed or security bugs they'd found. And that started me down this path of looking into bug bounties and vulnerability disclosure programs, and just generally sort of asking, how can we do this better from sort of a policy and process standpoint in a way that, ideally protects researchers better and allows them to, do this sort of beneficial, helpful work. After a few years at the firm I was with doing that, I went to GitHub as one of their in-house counsel, and during that time, oversaw sort of a full overhaul of their bug bounty program, including taking what had been a pet project of mine for a few years before then, basically a better bug bounty program policy involving a strong legal safe harbor, tailored to the sort of practical realities of what that entailed and what was necessary to really do that in a robustly protective way. And so we overhauled that entire process, and then shortly after that policy and the rest of that program was adopted pretty much wholesale by Microsoft.
Okay. So you mentioned overhauling GitHub's process. I don't know how much you can go into it, but what was GitHub doing before? And then when you were brought in, what were the changes that you made that updated this? I mean, was it just they were needed to change with the times, or they just had an unrealistic expectation of vulnerability disclosure? I mean, what was the changes that you helped implement there?
No, that's a great question, and I think like it sort of speaks to the, let's call them like evolutionary phases of vulnerability disclosure and bug bounty process. They had a program already when I sort of stepped in the door, but it hadn't been touched in at least 4 years. And one of the things that had become much more common in the interim period was a shift from this, either extremely informal one or two sentence sort of vulnerability disclosure process guideline statement, to sort of at best what GitHub had at the time, which was a primarily security owned, fairly non-legalistic bug bounty program that sort of had more or less a gentleman's agreement to not aggress against outside researchers who disclose to the program. But it's it was what I would describe as very informal, probably legally unenforceable. And the thing that had changed in the interim was really the shift away from that more kind of neighborly, informal method of doing vulnerability disclosure to a somewhat more formalized process of having sort of enumerated policies about how these are to be disclosed or where these are to be disclosed to, as well as a growing push for strong legal safe harbor in those programs. And I can go more into depth on what legal safe harbor means, but the sort of very, the one or two sentence version is legal language that provides formal protection to outside researchers from either civil litigation or criminal prosecution, as retaliation for their disclosure.
Right. Yeah. Before we started talking or recording the show here, I had suggested it was like a copyleft for security researchers. It seemed like that there was, you do see stories about companies who, from a researcher, hey, I disclosed this to X company, and X company automatically slapped me with an NDA, gag order. And, then, sent, the next discussion I had with them was from, Dewey, Cheatham and Howe lawyers, the in-house saying, hey, please, don't disclose this or we're going to sue the hell out of you and put you in the gulag or what have you, which I can understand the legal safe harbor and, dealing with security researchers, making sure that they have guarantees from that company that, they're not going to get that. So that's excellent. I do appreciate the proactiveness there, because there is a safety there that a lot of researchers don't expect from major companies. So.
Yep, exactly. And, I think it's ultimately a two-way benefit. And I think that's why legal safe harbor has become a pretty popular thing for especially larger companies to implement. Is like, look, the company has better results from a bug bounty program or an open vulnerability disclosure inbox when they know the people going that route get legal protection in exchange for it.
Right. So is there a difference? So do companies implement vulnerability equity programs, or is that and I don't mean to shift gears here, but the vulnerability equity program, when I first looked it up in Google, came up with a Wikipedia article about something the government implemented, and it was based on a blog post in 2014, which, it feels like forever ago, but the blog post is from talking about Heartbleed and the need to understand when we disclose cyber vulnerabilities. And there's been, a number of articles about how, companies are sitting on O-Day or they don't disclose this stuff. And so are vulnerability equity programs more of a group-based activity, or can a company have an equity program? I'm just trying to figure out if this is a group thing, like, where an ISAC would decide to disclose this, or if, let's say a GitHub has a vulnerability equity program. What does that look like for a small company or a company, period?
Yeah. So as far as vulnerability equity programs, I'm really only familiar with those in the context of government programs.
Okay.
And I'm speaking outside my expertise a little here because I have not
Sure.
worked for any federal or state government. So I don't know. I only have limited insight into how it looks in there. But
Right.
from what I've read on VEPs, it seems sort of similar to a slightly more rigorous and codified version of a company style vulnerability disclosure program.
Mm-hmm.
Um, and my at least vaguely informed guess would be that that is possibly because a lot of vulnerability disclosure or bug bounty programs within companies take a pretty fast and loose approach to determining what is, say, a critical bug that gets high payout versus what is a minor issue that gets some company swag.
Right.
Whereas governments almost always have to be much more rigorous in documenting and determining how any sort of reward or funding is given out to people who have given them some benefit. So I'm
Right.
guessing a bit blind there. I could be completely off, but that would be my guess.
Yeah. Okay. Yeah. And my thinking was, VEPs only work for the government, like you said, because, they're finding, FBI, for instance, there was a news story about them setting on a decryption key, or
Yep.
running operations from a somewhat shady point of view, because they're trying to, if they disclose that vulnerability, then they're burning a potential
Right.
operation or something like that. So for the good of the many, they're trying to not blow that, and try to cast as wide a net as possible.
Yep.
So some of the messaging that came out from that blog post in 2014 was, how vulnerable is the system that is being used? If left unpatched, what's the significant risk? With corporations, they're actually now required to declare, that there were vulnerabilities, or if that vulnerability resulted in a breach. So, is that why that they don't have to worry about? So wait a minute. Let me backtrack here. So,
all right.
They don't have to worry about vulnerability equity because they're actually forced to disclose whether or not they had vulnerabilities or breaches or what have you.
So you're getting into a very interesting distinction in this area, which is that a vulnerability is not necessarily a breach.
Correct.
And I think it is. I suspect that's part of why VEPs and VDPs are sort of in these different universes.
Mm-hmm.
But yeah, I think only I'm not aware, even in like fairly highly regulated industries, of sort of a legally mandated disclosure of vulnerabilities, even if they haven't been exploited in any way.
Right. So, I have worked at companies, and I told you at least one of them that I had worked at before. So how different are embargoes versus VEPs? Because it seems like that there may be like a VEP process here for, like, let's say Red Hat or Zen.
Yep.
Because hypervisors, arguably, large companies with large cloud infrastructure would tend to maybe use various types of hypervisors that are based on Zen. So
yep.
There have been, in my vulnerability management days, oh yeah, here's big bad vulnerability from Zen. Oh, we can't tell you about it until we disclose it to other folks. So
right.
It seems like that there might be some kind of VEP-like process in larger companies like this.
Yeah. Yes. I definitely, there are like practical similarities, if not identicalities to them. Yeah.
Right. Yeah. So I just wondered, what kind of questions companies like that ask, for disclosure, because it just seems like there may be, kind of a haves and have nots, like who do we tell? Are we trying to do the 80-20 rule where, we disclose to, what would affect 80% of the internet versus 20, and, I'm thinking of larger things where it's like, bad guys won't target for instance, the Amazons of the world, if there's a Zen vulnerability, they would target, the 500 other companies that didn't, get invited to the embargo in this, so there's we have a couple of links in the notes talking from Red Hat about security embargoes or Zen's security policy on notifications and disclosure. Are embargoes, in this case, VEPs, kind of by definition, are those a good thing or a bad thing in aggregate?
That's a wonderfully complicated question. So I think embargoes are extremely common as a feature of any sort of vulnerability program or bug bounty. I think that the details of like how that embargo is set up, who is sort of within or without that, or who's sort of inside or outside of that embargoed loop, how strictly written or enforced the relevant NDAs that are sort of the foundations and enforcement of that embargo look. These all vary really wildly. I think there's arguments that go both ways, and let me present both, and then maybe push my finger on one side or another of that scale to where I fall on it. I think the arguments for embargoes, especially like a Zen hypervisor, is a great example of like this is used widely across the industry, across very wildly different scale or size of companies across the industry. And a vulnerability there is going to affect, like you say, hundreds, if not thousands of companies. I think one of the arguments in favor of strong embargoes is a lot of these larger companies. A lot of these larger companies do not have sort of the nimbleness to, hurry and patch a thing that may, especially if they're, say, a finance or a healthcare actor or someone else in a highly regulated industry. If that vulnerability is publicly disclosed and then exploited by some other party, now they're facing significant regulatory risk. They're facing a whole lot of reporting requirements that place a pretty large fire underneath them. So to that extent, one of the arguments in favor of embargoes is it gives larger companies time to sort of rally their resources and respond and hopefully patch the vulnerability. Likewise, for smaller companies who may be more resource thin, who may need time to just plain sort of redirect priorities or reassign security staff to fixing that problem, it's sort of a similar argument. It gives everyone kind of more time to respond before this goes public and becomes something that anyone with this knowledge could exploit. And then, like you sort of pointed out, especially if you have sort of a more complex embargo process where you have kind of an information sharing group looped in, it allows that it can allow the collaboration to happen in a somewhat less time pressured way than with a just immediate public disclosure. Right. On the other hand, the arguments against embargoes are, as long as that information is non-public, everyone who's not invited into that room or who isn't looped in on this vulnerability, like you said, is just unaware of it and exposed to anyone who decides to use that. It also means that that vulnerability disclosure is only disclosed to a select few, and if any one of those select few decides to begin exploiting that in any way, you've got a much wider population who does not have the information to respond defensively. And I think one of the other arguments against is that it is often I think especially with sort of indefinite embargoes or indefinite NDAs, it can become a tool that allows companies with leverage to enforce those sort of agreements to simply not fix something that they really should. And if I'm sort of like disclosing where I fall on this, I think there are arguments for process, and I think on a case-by-case basis, a time-limited NDA or embargo can be useful if there's some, good factual reason why time is needed to, create a patch or set up a defensive filter or do to undertake some technical steps necessary to mitigate the risk. But by and large, I think it is all too often used as just another means to keep researchers quiet and deprive smaller actors from the information necessary to protect themselves. I see all too many situations where a vulnerability has either gone unpatched or gone completely unspoken of because of these types of embargoes in a way that may make the larger actors who are enforcing those embargoes happier and safer for a while, but on net do more harm than good to companies at large who are being exploited by this passing around. I think the other problem is the reality is if something's vulnerable and one person's discovered it, odds are other people will eventually as well. And if you've embargoed your white hat bug bounty participant, that does not mean and use that to delay or prevent public disclosure in a way that prevents a fix being developed. You are putting everyone at risk that if anyone else is aware of or has access to or discovers the same vulnerability, they're that actor that next actor to discover it may not be so polite or benevolent about how they disclose that. So you're not really eliminating the risk by enforcing that embargo.
Right. So not to go back to the legal safe harbor thing, but so you have published a list of expectations that the company will have to the security researcher with the idea that the security researcher is going to act in good faith towards your organization. Now, obviously, it sounds like the safe harbors, legal safe harbors, and things like embargoes are mutually incompatible because embargoes would mean you can't disclose this. Does the legal safe harbor also have protections in there about you also can't disclose this until we fix it? So what does communication look like there?
Totally. This is another thing where it varies a lot by company, and I think in some ways needs to, because every company is going to be a bit different in terms of what their security risks are, what their legal risks are, how fast they can respond, how, let's say, just plain old averse to negative security publicity they are. So that part varies a lot. There's certainly out there in the universe of sort of modern day bug bounty programs or modern day vulnerability disclosure policies, there are plenty that include a NDA section or an embargo on public disclosure. I think the better examples, in my opinion, of ones that include that type of language put either a soft or a strict time limit to it. I think one of the more common examples is by disclosing this to us, that starts a timer running after which let's say 180 days or 90 days, depending on depending on the policy. After that, you may disclose it. So I think that strikes an all right compromise between the public interest in knowing what is out there in terms of security vulnerabilities, and giving the company sort of the benefit of time to respond to something, especially if it really is. I think quite a number of these, especially in let's say, maybe not the 0-day realm of things, but more like the misconfigured S2 bucket sort of realm of things, are pretty company specific. So it is sometimes a feature of them. It is certainly not necessarily a feature of a modern bug bounty program, and I think that ends up sort of being a separate policy question. The way it interacts with a legal safe harbor is, it's sort of a question of what do you, as say, the security team in a company setting your internal policies for this, want to require of researchers? Let's say if I say, hey, sure, here's robust language that protects you from us either going after you legally directly or going after you, by means of law enforcement. If you want that benefit, you must agree to keep quiet for 90 days, or you must agree to sign this NDA and not go public at all until we decide to disclose this. And so, maybe maybe you're a company who thinks that that's worthwhile because you've got a high amount of business risk from security issues, and you've got, you know, let's say really good payouts on your bug bounty program. So you're confident that researchers will be enticed by that and not turned away. But
Right.
you know, I think the more sort of restrictions you put on people disclosing, the more researchers, you know, the more outside researchers are going to go elsewhere and say, you know, that's a lot of hassle. That ties my hands in a way I don't like. I'd rather, you know, look for bugs on this company's site instead. And so,
Right.
yeah, I think it's sort of this cost benefit analysis of how many people will we turn away with this restrictive policy versus, you know, how much better off are we by having those restrictions.
Cool. Yeah. Okay. So we talked a little bit about trust here. You know, making sure that, you know, there's trust on both sides, coming from the company itself and also the security researchers or a company. Maybe there's a company like Randery that has, you know, disclosed this to Palo Alto. You know, I'm assuming Randery had made the assumption, and I'm, you know, again, we'd have to probably get MG on to talk about this, but Randery had assumed that in some kind of, you know, Schrodinger's cat kind of thing, that this was an O-Day because, you know, nobody had disclosed it, or they had thought it was at the time. But after finding out that it was actually in a preferred patch in October 2020, yeah, they actually outed themselves on Twitter and said, "Hey, did anybody not notice this? Whether it was from a poor change log or something, or Palo Alto buried it, or what have you," which is another show altogether about, you know, proper change logs. So, so which one is easier to set up in your opinion? And I'm just, you know, your opinion and seeing how everything was done at GitHub. Is a bug bounty easier to set up, or should you have, you know, the vulnerability management program, and then once you feel comfortable with the vulnerability management program, setting up the bug bounty? Or, you know, does it matter, or should they both be in tandem?
Oh, that's a really good question. And I would, you know, from sort of the more InfoSec side of this, I suspect that Katie Masuris would have interesting things to say on that question as well.
Yes.
But yeah, I think, you know, if you are a company that does not yet have either a process or just plain old the resources to manage and remediate vulnerabilities, a bug bounty program is only going to be so helpful. And I mean, you know, sort of synonymously, a vulnerability disclosure program or vulnerability equity program is only going to be so helpful, because at the end of the day, you know, what you're receiving from these outside parties who participate in those programs is essentially intelligence about what you've done wrong and what is vulnerable on your system. And, you know, I think I definitely saw a few moments when sort of, I don't know, I see this kind of happen every time that bug bounty programs come up as sort of a hot topic in the security world. You know, you'll see one or two companies who, for whom that is completely premature in terms of the sort of stage of their and sophistication of their security program, say, "Oh, yeah, we've heard of bug bounty programs. Those are cool. We should have one of those." And inevitably, if they don't have the internal resourcing to take that intelligence and act on it, it's just wasted time and money and wasted resources to stand that sort of program up. I think there is kind of a middle ground solution of, you know, a bug bounty program is a pretty broad term and defines everything from, you know, someone running a Bugcrowd or HackerOne setup with, you know, highly detailed, high value payout programs tiered on level of severity, down to having an inbox someone checks once a week that says, "Hey, if you find security issues on our site, send it here." You know, those are all bug bounty programs. So like, there's plenty of nuance in terms of how those can be set up, but I think like really at the end of the day, that needs to be tailored to, you know, what does your management program look like for vulnerabilities? What does just your plain old sort of security resourcing look like to fix those bugs once you're informed of them?
Right. Right. And you mentioned threat intelligence where, somebody's disclosing that to you. There's quite a bit of nuance there, right? Because somebody
Yep.
who finds something in your, vulnerability in your program, they probably have an idea of how much they think something should
Yep.
cost because,
Yep.
they're involved in the dark markets or what have you. And then, this would be worth $150,000 to somebody, and you disclose it to, Joe Bob, Billy's, software company. And they're like, well, here's a free t-shirt from the company's website or something like
Right.
that. So I don't want to blame the researcher, and I don't want to blame the dark market. Well, I do want to blame the dark markets, but, is it realistic to believe that, a company could pay $150,000 for the vulnerability? And are we still basing bug bounty prices and costs and disclosure costs on, fair market value, or by the inflation of it in a dark market? I don't know if you can speak to that, but it just seems to me like, you can only pay so much. If a dark
Yep.
market's willing to pay $1 million for an RCE, on an Android tablet, and
Right.
What is fair market value? Is it the dark market value, or is it the value that the company can be willing to pay? Because that does cost budget.
Yep. I think like this is another one of those things, like you could probably do a whole show just on the question of, how do you correctly value the tiers in your bug bounty program? That it's not an easy topic, but I think sort of in broad strokes, this is one of the arguments in favor of legal safe harbor. By having a program where your researcher is, protected from costly legal involvement by disclosing through the company. I think like just in sort of like an Econ 101 sense, that creates a significant discount on the fair market value, like, of let's call it the dark market value of, hey, someone on Silk Road 15 says they'll pay $1 million for this. Right. But if you accept that, and that person, uses that irresponsibly and is arrested and charged and points a finger at you, that $1 million is no longer such a great deal. Right. If you get to keep it at the end of the day at all. Right. So, I think one of the sort of policy and like economic arguments in favor of strong safe harbor is that, it now allows me, the company, not to say, hey, tell us about this and we'll send you a t-shirt, or, tell this dark market about it and you'll get, hundreds of thousands or millions of dollars. That's no longer the discussion. The discussion shifts to, tell us about this and we'll send you, hopefully better than a t-shirt, because if it's really that far off from the dark market value, then you've probably undervalued the vulnerability. Like there's still a complex discussion internally to be had about, what's low value, what's high value, what's really, really high value. So, if you've got that level of maturity in your sort of security team and have valued it at least somewhat correctly, it allows you to say, well, all right, rather than sell on the dark market for $1 million and the risk of prosecution down the road someday, you can send it to us for, let's say, 10,000 and guaranteed protection from that, at least as far as we're concerned.
Right. Yeah.
But yeah, I think I think roughly speaking, the fair market value is how much could this harm the company, and what other benefits are we offering to this person to come to us instead of the darknet?
Yeah. I guess it ultimately matters on how shady the hat of the researcher is, if it's white, gray, or black, And that was it for part one of our discussion with Fred Jennings, Esquiring on Twitter. You can follow him on Twitter at Esquiring, ESQUIRING, as well as all of our podcast co-hosts. Miss Berlin can be found at InfoSyster, INFOSYSTIR. Mr. Betcher can be found at Betcherpwned, BOETTCHERPWNED. You can follow me at Brian Brake, BRYAN, BRAKE. And the podcast is at Brakesec, BRAKESEC. You can find this podcast and 350 hours of podcasts that have stretched back 7 years on our official website, brakingsecurity.com, BRAKEING security.com. And we'd like to thank all of our Patreon supporters for their help and assistance in, tipping us a bit for hosting fees, Zoom fees, Libsyn, for putting out a regular podcast on a weekly basis for the last 7 years. We definitely appreciate everyone helping us with that. So we'll be back in 2 weeks with our discussion with Fred Jennings. We'll discuss talking to senior personnel on how to set up a VDP system. Sometimes we don't understand the hidden costs involved of setting those up, so we're going to talk a little bit about what that entails. Also, the real costs and how many times you actually will pay for a vulnerability, not just paying out a bug bounty person. So, hope everyone has a great week. Talk to you again soon. Be safe. Take care of one another. Be nice, and take care of yourselves, as we always say here, because you're the only you have. And we'll talk to you again soon.